Okay, so once again, welcome everyone to the weekly CAS SEE Seminar with our guest speaker, Péter Techet. Very happy to meet you. I hope I did not butcher your last name. Apologies if so, but we are very excited to have you with us and to hear the intervention and enter into dialogue around the topic of the role of the judiciary. And the subtitle of your lecture will be Interpreting versus Creating Law, or How Hans Kelsen as Constitutional Judge Justified Judicial Activism. And I will let the presenter and respondent for today, our fellow Dr. Nicola Camilleri, perhaps say a few more words about the session and the guest speaker very shortly. So let me just briefly introduce him. Dr. Camilleri is a historian specializing in the history of Europe, especially Italy and Germany, in the 19th and 20th century, from a global and post-colonial perspective. He received his PhD from the Freie Universität Berlin in 2017 and worked from 2019 until 2022 in the ERC project, The Dark Side of the Belle Epoque, Armed Associations and Political Violence in Europe Before the First World War, a project based at the University of Padua. And as a result of his work in Padua, he's currently writing a book on shooting associations in Imperial Germany as an expression of popular militarism and middle-class sociability. Prior to his time at CAS, he has been a fellow at the NYU Remarque Institute in New York, at the Leibniz Institute of European History in Mainz, and at the German Historical Institutes both in Rome and Warsaw. Nicola's first monograph on citizenship policy in the German and Italian colonies was published by the Max Planck Institute for Legal History and Legal Theory in 2021. So welcome, Nicola. I leave it to you to introduce today's session and guest. Thank you.
Thank you so much, Valeria. This is a pleasure to be here and to give a good friend of mine a chance to speak at our seminar series. This is indeed the session of this seminar program of the Center for Advanced Studies of Southeast Europe, where I have been fellow in the last month. And this is the second seminar in a row. Let's say last week we had another topic, a very different topic related to the research I'm conducting. And today we have a very different approach and a very different topic. The title of the presentation of Péter Techet today is The Role of Judiciary Interpreting versus Creating Law, or How Hans Kelsen as Constitutional Judge Justified Judicial Activism. Very obscure, but maybe not, at least for me. Let me introduce our speaker and then give a few words on his paper, on what will be his paper. Péter Techet is a lawyer and a historian. He received his PhD from the University of Mainz, and in his PhD in modern European history, he deconstructed the narrative of nationality conflicts of the late Habsburg monarchy by focusing on the Upper Adriatic region. Then this is the reason why I wanted him to speak at our seminar, because actually Péter Techet is very familiar with Rijeka and the entire region of the northeast Africa and the Habsburg Empire at the wall. He has been a researcher at the Leibniz Institute for East and Southeast European Studies at Regensburg in Germany, and at the Leibniz Institute of European History in Mainz in Germany as well. He has been a visiting fellow at the Austrian Historical Institute in Rome and at the Remark Institute at the NYU in New York City, as well as at the University of Genoa. Actually, right now, currently, is a postdoctoral researcher at the University of Freiburg in Germany and at the University of Zurich in Switzerland, where his habilitation will be based. Basically the second big book project on Hans Kelsen. So his recent current research is on the historical contextualization of Hans Kelsen's pure theory of law, especially on how the post-Habsburg legacies and Kelsen's experiences as constitutional judge in Austria shaped the theory. So there's much food for thought, let's say, in this, because let's say that this research is also motivated by the fact that in 2023 is the 50th anniversary of the death of Hans Kelsen. So there is, I suppose, a lot of conferences and workshops going on. And also because basically just Hans Kelsen is one of the most influential and legal scholars and very popular also among not specialists of like legal, I mean, history of law, let's say. But I think the interesting aspect of this research is not that, so far I can say, let's say, it's not that it's just, let's say, embedded in the history of ideas, or in the history of philosophy of history, but also in a way in a social and cultural history in which Hans Kelsen basically operated. So this is just like my short introduction. I don't want to take more time to our speaker. So I'm very much look forward to hearing Péter and his talk today. And I thank him very warmly for having accepted this invitation. Thank you, Péter.
Thank you very much for this kind invitation and words about my researches. Yes, Hans Kelsen is very famous for this pure theory of law, and I'm trying to make the theory a bit impure. So because even a pure theory of law is a product of a concrete historical situation. And my hypothesis is that Kelsen as a constitutional, so Kelsen as a post-Habsburg with his post-Habsburg imperial biography and as a constitutional judge in Austria in the interwar period. So these experiences were maybe the most influential motivation for Kelsen to make this kind of pure theory of law, which is maybe not so pure, but based on a very special Habsburg legacy and a very special situation in Austria in the interwar period. So thank you very much for inviting me. Dobar dan, Urieku, buona giornata a Fiume. I used to live in Fiume, that's true. And even Hans Kelsen has a small relation to Fiume, because after the First World War, as Riccardo Zanella tried to construct a new state in Fiume, so it's not the D'Annunzio state, but it's the Free State of Fiume. Kelsen was who wrote the constitution of the Free State of Fiume. At this time, Kelsen was writing a lot of constitutions, so it was like a constitution-making fabricatory for Kelsen, because he wrote also constitutional text for Liechtenstein, for Austria, even for Czechoslovakia, but also for Fiume. Giulio Segui, he was a lawyer in Fiume, and he tried to get Kelsen as legal scholar also for Fiume. So yes, my talk is in between, because it's legal history, cultural history, but with a lot of legal theory. So maybe it will be quite boring, but I hope it will be understandable. So I'm trying to share. Where can I share my bildschirm?
condividi schermo or...
Can you see?
Yep. Yes.
Okay. So the role of the judiciary interpreting was creating law. That is maybe the more theoretical question. How Hans Kelsen as constitutional judge, justify judicial activism. As considered justify judicial activism. So my talk aims to examine the possibility of interpreting Hans Kelsen's full theory of law, specifically his theory of law application and law interpretation, as a theorization of the experiences of an active and in many ways activist constitutional judge. By emphasizing the political character of law application, Kelsen was actually responding to the then conservative government policy in Austria in the interwar period, which tried to so-called depoliticize the Constitutional Court. Of course, it was a political attack against the Constitutional Court, but they called it as depolitization of the Constitutional Court. The debates of that time could be quite familiar to many in today's Poland and Hungary. Accusation of a political power of judicial review, etc., restructuring the Constitutional Court in interest of a conservative authoritarian government policy. However, Kelsen as a judge developed a radical realist theory for justifying the political law-creating power of the judiciary. So what is interesting is Kelsen that he didn't refute the political character of the judicial review. He claimed that the judicial review should and could be political. There is no other way, and that is the connection to his whole legal theory, where he understood legal application as lawmaking process. So Hans Kelsen, whose 5th anniversary of his death, as Nicola said, will be commemorated in this year, is still one of the best known, most influential legal scholars, particularly in Italy or in South America, in Austria, in Germany, maybe less. With his approach of describing the inner logic and structure of law in a purely legal way, he also supported an anti-ideological view of law and jurisprudence. So the full theory of law, Rechtslehre, that is his famous book, but also the whole theory called full theory of law. Kelsen's main academic achievement is so the full theory of law, with which he, on one hand, set up a comprehensive theory of positive law, on the other hand, wanted to cleanse the earlier legal thinking of all ideological, metaphysical, religious, political, etc. elements. Because Kelsen started from Kant's basic hypothesis that knowledge determines the object and not vice versa, Kelsen took a knowledge reductionist position. What he described was not the law in all its aspects, but the law in the form of norms and processes as the subject of legal research. Kelsen distinguished the object of the pure theory of law not only from being, so sein, but also from values, which per se belonging to oaths, so sollen. The demarcation from being excludes a positivism related to facts, so it was a legal positivism without naturalism, while the demarcation from the oath, sollen as value, overcomes the natural law thinking, so it was a normativism without moralism. Kelsen's legal formalism and positivism is a product of the Habsburg legal thinking, because if we look at the Habsburg Austria, so I'm not meaning only the whole Habsburg monarchy, but mostly the Habsburg Austria. Habsburg Austria was after 1867 a Rechtsstaat, a state ruled by the law. Because of the national polarization within the state, there was only one element, the law, which could held together the state. So that's why this typical Habsburgian legal thinking was shaped by a strong formalism, legalism, positivism, without any metaphysical ideas about what the state should be, etc., like the German scholars did in this period, who tried to define the state as whatever. For the Austrians, the state was nothing else but administration, for a quite complicated empire, and it was better not to go quite deep into the debates about the state. It was only the law, and it was a legal community which held together the Habsburg state. So we can see some Habsburg elements from the Habsburg monarchy in Kelsen's pure theory of law, why the state is a legal order, nothing else. For Kelsen, there is no state, or a state is only a synonymous word for legal order, and also legal community doesn't need a national homogeneity. So the law is the state, and the state can function even without any common homogeneous basic, and that's why he defined democracy as relativism, as guarantee as pluralism, as compromise. Of course, we can think on the Ausgleich of the compromise of 1867. So for Kelsen, the whole politics, the whole legal life was based on compromises in a quite complicated, structured legal framework without any national, religious, and other metaphysical ideas. So that's why we can define the pure theory of law also as a cultural product of the Viennese modernity. So for example, Kelsen said himself that the pure theory of law is a doctrine of the state without a state. And he said that he saw a similarity to Freud, to Ernst Mach, to Wittgenstein, because Freud's theory is a theory of soul without soul. Ernst Mach theory is a theory of force without force. Wittgenstein's theory of speech acts as a theory of language without language as a substantial element. And in this sense, also the pure theory was a theory of state without state. So Kelsen located himself in this Habsburg background. So he said, it may be that I came to this point of view, so state as legal order, etc., at least because the state that was close to me and which I best know, the Austrian state, so I'm in the Habsburg Austria, was apparently only a legal entity. In view of the Austrian state, which was made up of so many different groups according to race, language, religion, and history, theories which try to base the unity of the state on some social, psychological, or social biological connection between the people who belong to the state must turn out to be fictions. So that's why he tried to justify the state without any substantial categories, only as a dynamic process for a quiet pluralistic society. Also, Erich Voegelin, the famous philosopher, relocated Kelsen in this Austrian context, but for Voegelin, it was meant as a criticism on Kelsen, because Voegelin blamed the Habsburg monarchy and the Habsburg legal thinking for the absence of an Austrian nation, and especially the pure theory of law for this mental heritage, even in the first Austrian Republic. So Voegelin said that the pure theory of law was the abstraction of this kind of Habsburg legal thinking, and that is the reason why even the First Republic of Austria functioned without idea of a nation, only as a legal entity. So as I said, because Voegelin wrote this book during the authoritarian period in Austria, the so-called Austrofascism or corporative state, Voegelin said that it is the fault of Kelsen that Austria couldn't develop the national state like Germany, Italy, Hungary, whatever. So, but what I will talk about, it's more Kelsen's political role in the First Republic, so in Austria, the interwar period, because Kelsen, as I said, as a legal theoretician, is quite well known and well researched. So maybe there is nothing to say new about Kelsen's theory, but less well known is Kelsen's more political role in the First Austrian Republic. After World War I, he was involved into drafting the new Austrian Constitution, which is still the valid constitution in Austria. So it is one of the oldest constitution in Europe. And as constitutional maker, as I said, he was a really industrial constitutional maker for Liechtenstein, for Fiume, etc. But he was involved also into the constitution making process in Austria, and he institutionalized the judicial review. Of course, in the United States, a judicial review existed already, but it was a decentralized model because every court can review the legal acts. In Austria, in Austria, it was granted to one single court to review the legal acts of the parliament, and that was really something new in the whole legal history. But even this idea, so to review legal acts, was not so new in Austria. It has also its Habsburg sources and Habsburg legacies. After 1867, after the compromise between Austria and Hungary, the two parts of the empire, Austria and Hungary, took quite a different way of how they defined nation state, etc. Hungary developed more a national state. It was quite problematic for the Croatian population in Fiume. And Austria, because Austria was not a nation state, Austria tried to define himself only as a legal entity. And some aspects of the state power in Habsburg Austria were already under judicial review. So not only in the Republican phase, but also during the Habsburg monarchy. The imperial tribunal, the Reichsgericht, anticipated elements of constitutional jurisdiction with its competencies of protection of fundamental rights and in disputes over competencies. The Austrian legal scholar at this time, Ludwig Gumplowitz, who was a quite famous legal scholar in Graz and in Vienna, characterized the imperial tribunal as, quotation, the real constitutional court. So the idea of a constitutional court was already there in the Habsburg monarchy. The judicial review was also a hot topic among the legal scholars at that time. After the German Lawyers' Congress in 1862 raised the question of judicial review, the Viennese lawyer Henrik Jacques wrote one of the opinions in favor of its introduction because the German lawyers, the legal scholarship, they were quite skeptical about the idea judges should control the politics. But the Viennese lawyer Henrik Jacques was in favor of this idea, and he emphasized that the judge only had to apply valid, it means constitutionally correct law. An unconstitutional law would not be a law. So that's why the judge is not allowed to apply unconstitutional law, because unconstitutional law is not a valid law, it's an un-law. Georg Jelinek also called for a constitutional court in Austria. That is his book, Ein Verfassungsgerichtshof für Österreich, a constitutional court for Austria. So he also called for a constitutional court in Austria in 1885. However, Jelinek later shifted away from this idea and became more skeptical about the political power judges can have as controlling the legislation. The question of judicial control also arose during the so-called Bohemian constitutional crisis, 1912. After years of party political conflicts in the Bohemian regional parliament in Prague, which practically paralyzed the provincial legislation, Emperor Franz Joseph decided in 2 imperial edicts to dissolve the provincial parliament and establish an emergency regime in Bohemia. It was unclear how to classify an imperial edict, Kaiserliches Patent, as the constitutional theory did not recognize such a legal source. It was not the ordinance, it was not the law, it was not a statute. What is an imperial edict? The administrative tribunal of Austria characterized it as an emergency law. It means a statute with legal force, but but not enacted by the parliaments. But it was quite political idea and not a legal concept. Regarding this practice of emergency laws as imperial edicts, Kelsen noted at the time that the lack of possibility to strike down unconstitutional ordinances was, quotation, an unfortunate omission in our constitution, in the Habsburg Constitution, end of the quotation. Another Viennese constitutional lawyer, Edmund Bernatzik, had already discussed this lack as a problem, and in 1911 he prepared a statute about a separate ordinance tribunal as centralized control for every ordinance's edicts, but it was never realized. But the idea of a centralized control of norms, even if only for ordinances, as Bernatzik tried to do it, was already there in the Habsburg monarchy. After the First World War, constitutional courts were established in Austria, Czechoslovakia, and also Liechtenstein. Liechtenstein is quite important because it was an independent state, but till the First World War, Liechtenstein was more influenced by the Austrian legal thinking, not like today by the Swiss one. Also, the family of Liechtenstein lived in Vienna. They moved to Liechtenstein only after the First World War. So the idea of a judicial review was not new to these countries, but the establishment of a single jurisdictional institution for this purpose was indeed a really new concept in the whole legal history, we can see, because as I said, the judicial review, the American model of the judicial review is a decentralized model, so not centralized in one single court. The question of which country had the first constitutional court is a matter of debate between Vienna and Prague till today. So the new German-Austrian state, because that was the first name of Austria, the new German-Austrian state introduced a court called Verfassungsgerichtshof, Constitutional Court, in January 1990. So we can say Austria is the first country with the Constitutional Court, but this so-called Constitutional Court was indeed the mere continuation of the imperial tribunal with the same competencies. So it was nothing else. It was a new name for the old imperial tribunal. So this court didn't have the competency of striking down legal acts of the parliament. Therefore, if we focus on the competency of striking down statutes, Czechoslovakia was the very first country in the whole world which introduced the Constitutional Court, Ústavní soud, as repressive, centralized judicial review body in February 1920. Austria followed it in October 1920, so there are few months between Czechoslovakia and Austria, but it was the question which country introduced as first country in the whole world the judicial review. Then it's not Austria, but Czechoslovakia. In his autobiography, Kelsen described the Austrian Constitutional Court as, quotation, the section of the Constitution that was most important to me and which I regarded as my most personal work. End of the quotation. He was indeed involved in the constitutional making process, as I said, but it would be an exaggeration to characterize Kelsen as the father of the Constitution. Of course, in Austria, Kelsen is the father of the Constitution. That is a Kelsen hagiography in Austria, but it's maybe an exaggerated opinion to characterize him as a father of the Constitution or father of judicial review, because he was not a politician. He designed the new Constitutional Court and the constitutional based on existing institutional, primarily the Imperial Tribunal, and long-standing legal debates in Habsburg Austria and then in Republican Austria. Which is important for the question whether the judicial review is a judicial activist body or not, and how Kelsen was an activist judge or not. It's interesting that the idea that the Constitutional Court would be a democratically not really legitimized control of politics. There are similar opinions even today by describing the constitutional jurisdiction as a democratic usurpation of the legislative power. So it's quite interesting that these debates were already there in the Republican Austria. So the accusation of judicial activism against constitutional courts that review laws, such as the US Supreme Court or the Austrian Constitutional Court, has been ongoing, with some political circles criticizing the courts for overstepping their competences. We know all the news, even from the United States, about these debates. The accusation that the US Supreme Court is engaging in activism is not exclusive to one political ideology or party and can come from both progressive and conservative sides. For example, firstly, the progressives accused the US Supreme Court in the United States as of being activist, as the Supreme Court defended, for example, the neoliberal politics against the New Deal. And then the accusation of being judicial activists was an accusation made by the progressive sides against the judicial review. Also in Austria, both sides, both main political parties, the Social Democrats and the Christian Socialist, so clerical party, criticized the Constitutional Court when its decisions did not align with political expectation. Only a few words about Austria, the First Republic. Even today in Austria, there are three big political camps: the Social Democrats, the Christian Socialists, and the so-called third camp. It's not so important. At that time, it was the National Liberal camp, the great German party, but the most important debates were among Christian Socialists and Social Democrats. And it is also important because at that time only Vienna was a red province and the whole country was black, so clerical. Even the federal government was clerical, so there were a lot of legal debates between Vienna and the federal government, and the Constitutional Court had to decide this kind of legal debates, but those debates were indeed political debates between the Social Democrats and Christian Socialists, and that's why the Constitutional Court was involved into political issues. So I will mention two examples when political parties accused the Constitutional Court of being activist, of acting in an activist way. In 1922, the Social Democrats accused the Constitutional Court of engaging in judicial activism, although of course the term was not yet in use at the time. They are saying usurpation of legislative power, etc., are not the term of judicial activism. So they accused the Constitutional Court of usurpating the legislative power after the constitutional judges abolished the Viennese Act on house caretakers. It seems quite a banal issue, the house caretakers, but it was in Vienna quite important issue, and it was a Vienna's provincial statute, and the Constitutional Court abolished this statute. The legality of the Viennese ordinance on cleaning fees, also banal issues, but was quite important. So the Viennese ordinance on cleaning fees was being challenged originally, but Kelsen, as constitutional judge, convinced the other judges to also review and cancel the entire provincial statute of Vienna. It means the Viennese Act on house caretakers. The Social Democrat judge, Friedrich Austerlitz, because at the Constitutional Court there were neutral and party politicians as judges. And Friedrich Austerlitz, he was a quite famous Social Democrat politician at that time. He was also the editor-in-chief of the Social Democratic daily Arbeiter Zeitung, and at the same time he was a constitutional judge as well. So the Social Democrat judge Friedrich Austerlitz feared that this decision, so the abolition of the House Caretakers Act, would have serious social political consequences, but Kelsen argued that practical consideration must not prevent the Constitutional Court from examining a statute ex officio. End of the quotation. The Social Democratic daily Arbeiter Zeitung, of which Austerlitz was the editor-in-chief, complained about what it saw as anti-democratic attitude of the Constitutional Court. The newspaper claimed that the Constitution has not appointed the Constitutional Court to guarantee constitutionality. It was a false opinion, but that was the opinion of the Daily, and considered the abolition of the Vienna's statute on house caretakers as an attempt to, quotation, make the Constitutional Court a censor over legislation, which would manifest a kind of aversion against democracy. So we are in 1922, and we can see the same arguments used against the Constitutional Court's anti-democratic usurpation of legislative power, which has been using also, which I was using also today. Austrian social democrats generally believed that it was the role of parliament, so the politics, not the tribunals, to decide on political issues. They were afraid of a strong constitutional jurisdiction because a strong constitutional court could obstruct the realization of social democratic goals, particularly in the case of a social democratic federal government. Austerlitz warned against a strong constitutional jurisdiction. As we can see, it should be said that taking powers away from parliament and giving them to the courts is not always a democratic progress, and that was a quite widespread opinion among the social democrats at this time. Most important was the Christian socialist accusation against the Constitutional Court. The Austrian Constitutional Court became the subject of legal and journalistic criticism later on due to dispute over marriage law. It is a really complicated issue, the marriage law in interwar Austria. The debate centered around whether ordinary courts were authorized to declare new marriages invalid after dispensation from the impediments to marriage, because the Austrian General Civil Code, Allgemeines Bürgerliches Gesetzbuch, contained elements of ecclesiastical marriage law that did not legalize divorce for marriages of Catholics, between Catholics. With one exception, provincial governments were allowed to dispense from the impediments to marriage. It means it was allowed that the provincial governments could give a so-called dispensation from the impediments to marriages, and then with this dispensation, even Catholics could divorce and could remarry. After 1918, the Social Democrat provincial government in Lower Austria, which included also Vienna till 1922, almost automatically granted dispensation from the impediment of existing marriages for Catholics or those who were married to Catholics. It means he introduced in an indirect way the divorce also for Catholic citizens. But the problem was that the normal courts, so the civil law courts, didn't accept the dispensation. So it means that it led to a situation where people could live in different marriages regarding the administrative law or the civil law. So that's why a real problem in Austria, that the bigamy was therefore quite widespread in Austria, because people could divorce, could remarry, but the ordinary courts didn't accept the new marriages, and that was a question. The dispensation was important, or the invalidation by the courts. The Constitutional Court first confirmed the judicial declaration of invalidity of the new marriages of Catholics, with Kelsen standing in minority with his opposing opinion, because Kelsen opposed from the very beginning this kind of ecclesiastical character of the Austrian marriage law. However, the jurisdiction of the Constitutional Court changed significantly in 1927, as Kelsen convinced his fellow judges that the marriage debate represented a conflict of competences between administration and judiciary, which should be decided in favor of the administration, so in favor of the dispensation. Kelsen's theory of equality between judiciary and administration was particularly relevant in Red Vienna, where the administration was more progressive than the conservative judiciary. Whether there was a competence conflicts between administration and the other courts is highly controversial till today, because the administration decided on the dispensation and the judiciary decided on new marriages after the dispensation. So if we see it in a poor legal way, they deal with two different legal issues. But Kelsen constructed this kind of idea of competency conflicts between administration and judiciary, and he said the administration has had some kind of primacy over the judiciary in the marriage law issue. The new jurisdiction of the Constitutional Court also fulfilled the political goal of putting an end to the confusion in marriage law and indirectly enabling divorces. However, conservative circles, conservative politicians, legal scholars viewed this intention as usurpation of legislative power. They believed that Kelsen was advocating at the Constitutional Court for his own constitutional theories. They claimed that the Constitutional Court, was encroaching on the competence of the Austrian National Assembly by exercising legislative power itself. The Christian socialists wanted to depoliticize the Constitutional Court by launching a campaign against the Constitutional Court in their own daily Reichspost. As the president of the court, Paul Vittorelli, he was born in Trieste. He was an Italian-speaking lawyer, but he went to Vienna after the First World War, and he was the first president of the Constitutional Court. So as the president of the court, Paul Vittorelli complained in 1928 in his letter to Federal Chancellor Ignaz Seipel. This campaign quotation aimed to damage the reputation of the Constitutional Court and erode public trust in it, end of the quotation. Chancellor Seipel, Ignaz Seipel was a Christian socialist politician. Chancellor Seipel responded to Vittorelli that the Constitutional Court had a significant partisan character, as many of its members were appointed with the participation of political parties, making it an institution that could be influenced by party politics. And that's why the Christian socialists wanted to depoliticize the Constitutional Court, but it was more a response to the jurisdiction in marriage law issue and not a real depolitization. The amendment of the Federal Constitution in 1929 restructured the Constitutional Court. The constitutional judges who were originally elected for life lost their position. Even Kelsen lost his position as constitutional judge. He went to Cologne, etc. So the real goal of depolitization was achieved because the new Constitutional Court established in 1930, the new Constitutional Court no longer overturned judicial declaration of marriage invalidity. In the first decision about marriage law, the new court implicitly criticized the former one for judicial activism and stated that quotation, it is not the role of the judiciary to eliminate unsatisfactory legal situation, but rather the responsibility of legislation, end of the quotation. So conservative politicians welcome the new decision as quotation from the Conservative Daily as a victory of law and the end of Kelsen's influence in Austria. So we can see that this debate on judicial activism was an ongoing debate in Austria. At the end, it was more the Christian socialist side who tried to depoliticize the Constitutional Court, but this ideology of depolitization was also political attacks against the Constitutional Court because of the quite progressive marriage law jurisdiction of the Constitutional Court. So despite the criticism mentioned, which has significant consequences also for Kelsen, the relevant literature describes the Austrian Constitutional Court till today as one that practiced self-restraint, so no activism. In contrast to today's constitutional courts, which are often criticized for being too activist, the Kelsenian original model of the Constitutional Court is perceived as non-activist, non-partisan, very strict formalist, legalist one. For example, Agostino Carino, that is his book. It's a quite new book. Agostino Carino, he's a legal scholar from Naples. Agostino Carino argues in his latest book that the Kelsenian Constitutional Court primary focus on ensuring the formal unity and logical consistency of the legal system and did not attempt to defend a set of values against the legislator. Carino is you can say maybe a more right-wing legal scholar, and he is against the progressive judicial activism, and he tried to criticize the judicial activism by using Kelsen as a counter model, because for him Kelsen established a very formalistic, non-activist model of constitutional court. During the debates about the political role of the Constitutional Court in Austria, so due to the marriage law issue, particularly surrounding the marriage topics, Kelsen defended the possibility and necessity of a strict textual interpretation of the law. So we can see Kelsen advocated for a very formalist, legalist, non-activist judicial review at the beginning. He believed that this formalist legalist approach would ensure the primacy of the democratic legislature. In discussions about democratizing all stages of the legal process, Kelsen argued that democracy is realized through legislation, and the later stages, even the courts, should strictly apply the laws. No law creation, only applying the law, because that is the democratic necessity in a democratic state, that the laws are made by the legislation and not by the jurisdiction. He stated that constitutional jurisdiction requires a clearly formulated constitutional text without overly abstract principles, because if we want to have a non-activist constitutional court, we need a quiet, short and clear constitutional text, because of course it is quite easier to apply than a text with a lot of abstract ideas. Even that's why the Austrian Constitution till today is a quite formalist, legalist, we can say even boring text without any great ideas. So at the same time as Kelsen advocated this kind of formalist, non-activist judicial review, the Constitutional Court made a decision whose reasoning was indeed a prime example of self-restrained judiciary. It was about the Federal Renting Act, which the provincial government of Vorarlberg considered as expropriation that would not meet the conditions specified by other laws, because expropriation was only possible in the public interest, and Vorarlberg claimed that the protection of renting houses, protection of renters, would be a kind of expropriation. However, the Constitutional Court upheld the Renting Act and stated that only the legislature was competent to define the specific meaning of such general terms like public interest. So we can see this reasoning is really a fine example of non-activist, very formalist constitutional reasoning. It must be emphasized that the Constitutional Court cannot enter into a discussion of this question. The public good, public interest is a legally incomprehensive concept. It is exclusively up to the legislature to determine it. It is the main text of the legislature to form an opinion about the many conflicting interests, to favor what they consider to be the higher interest, or to reach a compromise between conflicting interests. However, the Constitutional Court must firmly refuse to express an opinion on such a question. Independent, liberal, and social democratic constitutional judges voted in favor of upholding the Renting Act, while Christian social judges voted against it. And in this case, the majority of judges actively confirmed the social political goals of rent control through their self-restraint positions. So we can maybe question the division between judicial activism and judicial self-restraint, because even the self-restraint decision is an active decision, but in favor of the status quo and not in favor of a challenge by the law. So while judicial activism is pushing for change, like in the marriage law issue, self-restrained judiciary can also be seen as an active decision to maintain the status quo. A constitutional decision to abstain from reviewing the norm is just as political as an open activist judgment. So there is no possibility to be not activist, because jurisdiction is decision, not knowledge. And in procedural sense, it's always correct. Therefore, the term of judicial activism is a purely political criticism. It means a form of name-calling, camouflaged way of saying judge with whom I'm not agree. While Kelsen first justifies the primacy of the legislature, as we said, as we saw, and the strict interpretation of the wording as a democratic imperative, and thus he could appear as a defender of self-restrained judiciary, as constitutional judge, he was more activist from the very beginning. He recognized the constitutional jurisdiction as the final decision-making power, and which had a lawmaking character as well, because if it's the final stage in the whole legal life, what the judge is saying, then the judge is making the law by applying it. This kind of activist position of Kelsen we can see only in the archives, because he practiced this kind of activist position as judge in the internal debates at the Constitutional Court. For example, in the internal debate at the Constitutional Court about the constitution of the Austrian Electricity Rules Act, it's not so important, in 1922, he stated that the actual question is essentially a question of subsumption. Of course, we could also subsume it differently. By resolving this question, the Constitutional Court exercised law-creating activity. As the Constitutional Court was established, we were all aware that it might do this. So Kelsen asked for the law-making character of the Constitutional Court as constitutional judge, but at the beginning, as legal scholar, he tried to defend the idea of the non-activist constitutional review. At the conference of the Association of German Constitutional Legal Scholars in 1928 in Vienna, Kelsen gave the first lecture on the question of judicial review, in which he attempted to explain constitutional jurisdiction in terms of legal theory and democracy. That was maybe the first time that Kelsen tried to justify the Constitutional Court in a theoretical way. That is this famous debate between Kelsen and Carl Schmitt. On the one hand, Kelsen justified the constitutional jurisdiction by applying the so-called theory of legal gradation, or Stufenbaulehre in nice German. This theory, Stufenbaulehre, on theory of legal gradation, was developed by the Austrian legal scholar Adolf Julius Merkel, a student of Kelsen, and it suggests that the law is not fully established at the legislative stage. So statute is not law. The law is more than the statute. So law is emerging at the further stages also. It means that also the jurisdiction, also the administration is making law, and not only the parliament, because the statute is only one step in the whole process of lawmaking process. This theory, so the Stufenbaulehre, highlights the creative lawmaking character of legal application, and it relativizes the absolute position of the statute. The legislation is not lawmaking ex nihilo, as it must also apply the constitution. So even the legislation is not only lawmaking, because for Merkel, the stages are at the same time law application and lawmaking. So for example, the legislation is law application from the perspective of the Constitution, because the legislators are applying the Constitution by making statutes. At the same time, also judges, the stage of the jurisdiction is also at the same time legal application and legal and lawmaking, because the judge applies the statute, but by applying the statute, he's making also new law. So that's why there is no strict difference between law making and law application, because every stage is are at the same time law application and lawmaking. Therefore, also the legislation is application of the constitution. Therefore, we need a constitutional body like the Constitutional Court who guarantees who control the constitutional application process by the legislation. And that would be the theoretical reason for the Constitutional Court. The Constitutional Court as a control body for the legislation as constitution application. On the other hand, Kelsen justified the Constitutional Court also as an important element in a pluralistic democracy. Democracy was for Kelsen, as I mentioned, pluralism, relativism, etc. And that's why the Constitutional Court was the body who protect the minority rights. It was completely different by Carl Schmitt. For Carl Schmitt, democracy is homogeneity. In a democracy, there is no minority, so that's why we don't need a body who protect the minorities. For Kelsen, minority and majority, they are the important elements of the democratic state. And of course, in the legislation, there is the majority who dominates, but we need the other body like the Constitutional Court who protects also the minorities, because without minority there is no democracy. That was Kelsen's position. For Carl Schmitt, in a democracy there is only one unity of the whole people. That's why the minority position are not allowed in a democratic state. That was Schmitt's position. So Schmitt opposed the idea of constitutional jurisdiction. He viewed democracy as requiring homogeneity and unity by eliminating any heterogeneous elements, and saw the protection of minorities as unnecessary and contrary to democratic principles. He argued that in a true democracy, there are no permanent interests worthy of protection, a permanent minority interest worthy of protection. Therefore, Schmitt believed that constitutional jurisdiction threatened the unity of the state and people. Here we can see also the difference between the Habsburg legalist thinking and the German metaphysical thinking. Of course, Kelsen, coming from a pluralistic state, it was quite clear that the state can function also in a pluralistic society like the Habsburg monarchy did. For Schmitt, no, the state is a people's unity and democracy is also a people's unity. So it's like a populist constitutional theory, we can say. And that's why Schmitt said that the guardian of the constitution would become the lord of the constitution. So it's really interesting that there are differences between Kelsen and Schmitt, we can see, but both Kelsen and Schmitt acknowledged the political character of the judicial review, but for Kelsen it was a necessary that the constitutional judges should act as political power, while Schmitt said that the political power of the constitutional judges was something quite anti-democratic, because the political power should be granted only to the legislation power and to the whole people's unity. Schmitt's criticism of constitutional jurisdiction anticipated many of today's criticisms, particularly those from the critical law studies movement in the United States, which aim to prove the legal impossibility and democratic illegitimacy of judicial control of politics. Ran Hirsch, Mark Tashner, etc. So there are a lot of American legal scholars who are criticizing the constitutional review with quite Schmittian argumentation. All criticism of judicial review have in common that they overvalue the competency of parliament to enact laws, as if the parliamentary system established an omnipotence of the legislature and an impotence of the judiciary. The criticism of constitutional jurisdiction as undemocratic judicial power is the continuation of a populist understanding of politics and democracy, which currently benefits political regime that want to weaken the control mechanisms like in Poland or in Hungary. So we can see the debate is about the political power of constitutional justice. And Kelsen left his very beginning position defining the Constitutional Court as a strict application of the of the Constitution, and he began to defend the political power of the Constitutional Court against Carl Schmitt, but against also the debate of depolitization in the First Austrian Republic. In his response, Kelsen challenged Schmitt's arguments by placing the strong emphasis on the political nature of the application of law. He questioned the traditional division between law and politics, or between lawmaking and law application. According to Kelsen, the application of law is just as much a political process as legislation. He stated that, quotation, there is only a quantitative, not a qualitative difference between the political character of legislation and that of the judiciary. Because, quotation, every legal conflict is a conflict of interests of power. Therefore, every legal dispute is a political dispute. We can say Kelsen anticipated elements of also of the critical legal studies by claiming that law is politics and nothing else. But maybe the main question is, what is law application? Is there a law before the application? And about this topic, what is law application? There was a quite important debate within the so-called Vienna's School of Legal Philosophy. That was the school of Kelsen, around Kelsen in Vienna. This question, what is the law application, affected also the role of jurisprudence as legal knowledge. Is there a norm before the application that the jurisprudence and the jurisdiction could recognize, as for example Adolf Julius Merkel claimed, or does the norm only emerge as product of the application of law that jurisprudence could only register, as Kelsen renegade student with Sander claimed? Although Adolf Julius Merkel, so the guy with the Stufenbaulehre, although Adolf Julius Merkel acknowledged that the application of law is a function of the will, he located this operation within the framework of possible meanings. Merkel distinguished between legal interpretation and legal application. He assigned jurisprudence the task of interpreting the norms, reproducing the content, but adding nothing to the norm that is not already inherent in it. Merkel defined interpretative jurisprudence as control of the application of law, so as control of the jurisdiction. It means, quotation from Merkel, law is what jurisprudence recognizes as true, end of the quotation. Therefore, the application of law or jurisdiction would not be a decision empowered to every result, but a decision about the correct meaning. Even if there is not just one correct solution, the application of law must stay within the framework of what is right and true. Fritz Sander is a quite really interesting legal scholar, completely unknown, even in the legal scholarship, because
I'm sorry, I'm wondering, sorry, Peter, for the interruption, very brutal.
Okay.
I'm wondering if we have overcome the time set. I'm asking Valeria because I think we are behind 45 minutes.
Okay, I'm already at the end. I'm already at the end.
Yes? Okay, I'm sorry.
No. I know. And it will be now too theoretical.
Yeah, also
so
because we want to have a discussion.
We can skip it. So,
sorry.
And Fritz Sander, he was a really quite interesting, but completely unknown. Today, he rejected and criticized Merkel's distinction between interpretation and application. For Sander, there is no law a priori. The application is the only process where the law is being made. In this debate between Merkel and Sander, so both Sander and Merkel were students of Kelsen, Kelsen did not take a clear stance. He accepted the legally recognizable framework of passive norm meanings as a theoretical barrier for application of law, but he later moved towards Sander's radical position. And that is interesting that at that time, as the Constitutional Court was under attack, both from the government and from Carl Schmitt, so both from the politics and the legal scholarship, Kelsen developed a more and more radical realist interpretation theory. It means a theory that justified the political power of the judges to do anything what he wants to do. So that's why that is the alternative Ermächtigungsthese, which means that even if there is a framework of the possible meanings of the norm, it doesn't mean that the judge should stay within this framework. So that's why for Kelsen, the law application was the only true authentic interpretation of law, which means that what law is we can see it only after the judge's decision. There is a contradiction by Kelsen, not also between Kelsen as defining the non-activist position of the Constitutional Court, but also between Kelsen defining the jurisprudence as knowledge and at the same time the jurisdiction as the authentic interpretation of the law. So who is saying what the law, the legal scholar or the judge? And Kelsen was quite contradictory on this issue. I can skip it because this radical theory of Kelsen is being radicalized in Genoa and Nanterre by Riccardo Gastini and Michel Troppé. Michel Troppé says that il n'y a aucun limite juridique à la liberté de l'interprète. So for Troppé, there is really no law before the interpretation. The law is what the judge says, and we cannot foresee what the judge will what kind of decision the judge will make. So for it is this quite theoretical debate about the law application and lawmaking is important also the judicial review, because firstly, Kelsen said the Constitutional Court is important because without the Constitutional Court, the Constitution would be lex imperfecta, or the Constitutional Court can increase the validity of the Constitution, but it means that there is a law, there is a Constitution a priori. We can, but we saw that Kelsen deconstructed the idea of a law of the law meaning a priori. So there is this contradiction within the theory, and at the end, in his famous book, Kelsen defined the constitutional jurisdiction not as a control of a logical coherence between the legal system, but only as a pure jurisdictional decision. So what is called unconstitutionality of the law is therefore what is called unconstitutionality of the law is therefore by no means a logical contradiction between the content of a law and the content of the constitutional, but a condition stipulated by the Constitution for the initiation of procedure that leads to the abolishment of the law, which was until then valid and therefore also constitutional. So even the unconstitutional norm is valid, and it became non-valid, it became unconstitutional only because of the judge's decision. That means that the judges declare the norms unconstitutional. They were constitutional, they were valid. So we can see this contradiction. So at the beginning, judicial review is a knowledge, and the constitutional has a quite clear text, and the judges have to apply the constitutional as a control mechanism of the politics. Later, Kelsen became more skeptical about the possibility of legal knowledge, and judicial review became a decision, an authentic interpretation. That's why there is no meaning of the Constitution a priori, only a posteriori. So what the Constitution is what the constitutional judge is making from it. Why this contradiction in the theory of Kelsen? As Giovanni Bisogni, the famous Italian legal scholars, emphasize, Kelsen's attempts to legitimize constitutional jurisdiction through legal theory reveal that the concept is fundamentally political in nature. So maybe there is no possibility to justify the constitutional jurisdiction in strict legal terms. It is a political idea based on a specific based on a specific form or democracy, etc. So the pure theory of law cannot justify the institution of constitutional jurisdiction itself, but it can explain its legal practice and political power. As a legal scholar, Kelsen was able to refute criticism he faced as constitutional judge. However, in doing so, he developed a radical realistic theory of the application of law, which, as Kelsen himself acknowledged, can undermine the whole idea of law as fixed order. If the content of law is not clear at the highest stage of the norm hierarchy, so at the constitution, which the other stages can recognize and apply, the predictability of the law turns out to be an illusion. That is the word of Kelsen. Instead of legal certainty, there is only a certainty of the judge. It means the pure theory of law justifies the legal body whose decisions, legal applications, determine the law. In a specific historical context, it was strategically useful to clarify the lawmaking and political nature of the constitutional jurisdiction. However, the radicalistic theory of application of law used for this purpose reveals the democratic weakness of constitutional jurisdiction. So this is the reason why it is important to contextualize in a historical context the pure theory of law, because this whole contradiction within the theory of Kelsen, defending at the end of a complete deconstructivist way of legal knowledge, can be explained only as responses to the political attacks Kelsen and the Constitutional Court in Austria was faced. So Kelsen's main goal was not theoretical, but political. He tried to refute the idea of a depoliticize Constitutional Court, which was the government goal in Austria. But by doing it, he ended up in a quite realistic, radical deconstructivist theory of interpretation. And that is the question, if we can use this theoretical consequences of Kelsen for justifying the Constitutional Court, maybe not, but we can see, and maybe this is important for Kelsen, why the constitutional jurisdiction is always a political power, and if we accept it or not, we could and we should accept it by knowing this political power of the constitutional judges, because there is no unpolitical jurisdiction if we accept the theory of Hans Kelsen. Thank you very much.
Thanks. Thank you. Thank you so much, Péter, for this very in-depth presentation of this topic, which is, I mean, central for, I mean, it touches upon a very central point of the institutional structure of our state until today. So these discussions are really, really very contemporary in a way, because we, on a daily basis, we face questions of balance of power in the state. Sadly, we have no time. We have little time for discussion. So I think that I will just set a couple of lines for the discussion and then collect 2-3 questions and then you answer very quick. I think that it's very important to underline the dimension of political and cultural, social, economic contextualization of these debates. And it's very interesting that you say, for example, that how Habsburg this story is. But I would also say that I wonder how much this is a very truly specific debate of the German-speaking Europe, because I found very interesting the slide in which you opposed Carl Schmitt and Hans Kelsen. But I wonder how much, for example, similar debates could have happened in other cultural and political landscapes, like the US, for example. But yeah, this is just one of the things I had to that came in my mind. I want to exactly give the audience eventually the chance to ask some questions. If there is anyone. I see Javier Toscano. Please go ahead.
Thank you very much for the very interesting presentation. I know about Kelsen, but mostly on deep and theoretical debates, not historical ones. So this was very interesting for me. I don't think it's really like a German debate. I mean, these theoreticians are very much quoted in legal studies and in different domains. Particularly, I think there's many things happening in the Americas, in the continental Americas, that go back to these debates, and not only the US, but also in Brazil in Peru, I mean, these are things that are happening right now, and it goes back to these debates. My question here is, like, I think that there is a tension. Of course, the legal and the political are here opposed, but I think there is also a tension that you probably didn't mention a lot, and it's the democratic side, and is that the issue that the judges are not elected, like the democracy doesn't go to elect the judges. And of course, they are individuals or subjects with a political opinion, but they are not elected or appointed. So I think that goes to the root of the question, like, yeah, this is a power. The justice is one of the powers that can come to play a political role, or a power role, but like, what does it do on the democratic side? Because if judges are not elected, then how to reconcile the whole process? That would be my question.
Maybe any other questions or comments? Also very like general. I see, yeah, two requests of Mattia Milos and Alvise Capria. Please, Matthias.
Can you hear me?
Yes.
Yeah. All right. So thank you for your presentation. I am actually a constitutional law professor at the Faculty of Law here in Rijeka, and there is a lot I could respond to in your presentation, both in terms of contemporary arguments and history, but I will restrain myself due to time limits. So I wanted to ask, and you seem to, your argument that there is a contradiction in Kelsen's theory is on its face persuasive. I would like you to comment on Kelsen's idea of the Grundnorm, so the fundamental norm of the legal system that precedes a constitution, because you seem to argue that the pure theory of law is not as pure because it is conditioned by politics and the circumstances of the time. But Kelsen himself presupposed that there is a political that the law has to contend with, right? So he did argue that the whole legal system is ultimately based on a decision that is not legal at all. So I would just like your brief comments on this.
Thank you so much. Alvise.
Yeah, thank you very much for your presentation, which is, I mean, full of insights, and which also raises numerous problems for the present. Of course, I will try to be really brief, because I wonder how much in reality Schmitt, with you know, all his problems, did not grasp you know, a problem that perhaps Kelsen missed. I mean, coming back to, you know, the debate around about the problem of the constitution guardian, like the Tutor der Verfassung. I mean, the Reich President was supposed to act not for Schmitt as a sovereign, you know, but as an effective guardian and regulator, in order to ferry out, you know, an increasingly eminent state of necessity, and we could say also uncontrollability of the Weimar situation, right? So this is why the true guardian of the constitution needed to be located within the judiciary power, but with the possibility, and that's what, you know, Schmitt stresses, the possibility to deviate from it as needed, right? So this is because, you know, the risk that probably Schmitt saw was to run the risk of a stalemate between judgment, right, and jurisdiction. So, you know, binding the guardian of the constitution to a specific jurisdiction, as in the case of Kelsen's proposal for a constitutional court, would not so much result, I think, in the politicization due to the content of the judgment becoming legal, right, and thus, you know, finding its own limitation in codification, but rather in the politicization of the jurisdiction. That was the problem, right? So an overstepping in the ordinary function of the jurisdiction towards an expansion of the jurisdiction itself, and this probably would cause paradoxically, right, an abuse of power. So I would like to I wonder which was your opinion about it. Thank you very much.
Thank you. Okay, Are there any more questions? So I don't see any. I think that we can start with your answers. There are 7 minutes left for the answers.
So to Nicola, the German-speaking Europe, I would say it's not only a German-speaking or inner German debates. Maybe by the terms, of course, it's quite hard to translate CAS terms into English. So the whole philosophical background is neo-Kantian for CAS, and that's why it can be kind of inner German debates. Even the idea that we have to justify what judges are making in a theoretical way, because for the United States it was more a pragmatical political question. For CAS it was a philosophical question, and that leads to the debate between Schmitt and CAS. So maybe the motivation was quite German, but that's true that this debate between CAS and Schmitt is an ongoing debate with new actors in the United States, in Hungary, in Poland, but also in Germany or in Switzerland, because Switzerland has no constitutional court. Switzerland maybe follows more the Schmittian way, that with the primacy of the parliament over the judges. And that leads to the question Javier Toscano regarding the election of the judges. Yes, it's a quite, that was the main question in the First Republic of Austria, because this depolitization idea emerged in Austria because of the election of the judges, because the constitutional judges were elected by the parliament, by the political parties. That's why even party politicians like Friedrich Austerlitz, etc., they were constitutional judge, and that's why also the whole debate, which is more democratic, which is more pragmatically correct, having a constitutional court only with legal scholars and laws professors by claiming some kind of neutrality. But of course, this kind of neutrality of the legal science is also a political idea, but it would be other topic. Or really having a more political impact on the constitutional judge by allowing party politicians as constitutional judge, because Friedrich Austerlitz was not only a party politician, but he had no legal degree. He was a journalist, not a lawyer. For example, in Switzerland, the judges, they don't need to have a legal degree because they are elected by the people. In some cantons, in some regions, they can be also, they shouldn't be lawyers. And that the election problem is really a democratic problem. Should we elect the judges? But then the jurisdiction is a quite clear political power, like the legislation. And then what is the difference between the legislation and the judicial power? It is a second parliament or whatever. Or should we accept this kind of ideology of the unpolitical, apolitical legal application, which is the German way, or also the Austrian way today, is that we need a neutral constitutional court with quite smart legal scholars who can control the bad politics, because that is, of course, an exaggerated way, but that is the idea behind the constitutional court, that politics is something bad, and that's why we need the neutral, apolitical legal scholarship as control of the politics. But that is interesting, yes, that Kelsen, as part of this game, he revealed the political characters of the judicial review, and that was also the contradiction in this theory, how to justify it, because by justifying the political power of the Constitutional Court, it can lead also to the construction of the whole idea, because if the Constitutional Court nothing else but the political power, we can ask really why we need to have this kind of second parliament or whatever. If the Constitutional Court is really the neutral, apolitical knowledge of what the Constitutional says, then it's a nice idea, but it is Kelsen who deconstructed this idea by emphasizing the really political character of the of the law. So this is Matija Milos, I think, who said that for Kelsen it was quite clear that the law is nothing less than politics, because Kelsen was against the natural law idea. He was against the order thinking, like in Germany. Law is nothing less than politics, and the pool theory is a pool theory of describing the unpoor character of the whole legal system. So for Kelsen, the whole society, even the legal system, are a bunch of conflicts, of interest conflicts, like in the Habsburg monarchy, and the legal system is nothing. It's not the natural law idea about the conflicts, but the legal system is part of the social political conflicts, but with the other communication forms. And that is also some system theoretical approach, that legal system is not outside of the political conflicts. It is a other narrative about the political conflicts, but judges and the actors of the legal system are also part of those political conflicts. But then we can ask how political the constitutional jurisdiction can be. So that is, yes, that is a problem, and I think that's why I'm saying that Kelsen approach was quite historical. So he tried to refute the idea of a depoliticized constitutional court, and maybe the whole idea of having a constitutional court is not a legal issue, but it is a political issue. What kind of democracy we want to live in a pluralist democracy, where we need to have a body for protecting minority rights, or in a homogeneous democracy like in Switzerland, where the majority of the people via referendums can say what politics should do, and the judges have to apply the acts of the legislation of the referendums. To the question to the Vice President, the grant of the Constitution, yes, for Schmidt it was a more concrete task, but also because of the anti-pluralist democracy concept of Schmidt, because the Vice President is a neutral power. I don't know why he was elected by the people, but for Schmidt, the Vice President was a neutral power in order to protect the unity of the state, the unity of the nation against the bad pluralist interest, mostly of the trade unions or the Social Democratic Party or whatever. So I think Kelsen was more honest by claiming the political power of his guarantee of the Constitutional Court than Schmidt, who tried to depoliticize the Vice President, even if the Vice President was also a political power. And if we look at the history, we can say the Vice President was not a guarantee of the Constitutional against Hitler. Vice President had a quite important role by deconstructing the democracy in Germany, while the Austrian Constitutional Court couldn't hinder the authoritative way in Austria, but the Constitutional Court had to be cancelled by the authoritarian corporative state after 1934. So it means that the Constitutional Court was indeed a guarantee of the constitutional, but of course it's a political power, but without army, without police. So of course, at the end, the stronger state can abolish the Constitutional Court, but the Constitutional Court didn't play the active role in deconstructing the democracy in Austria, like the Vice President in Germany. But if we have maybe three models, the Austrian one, the Swiss one, and the German one was quite a failure. The Austrian one was not a failure, but theoretically not a failure, but practically yes. And the Swiss model was the referendum, was direct democracy. And even in Switzerland, there was the authoritative way in the interwar period, but the end, the authoritarian way was, but the referendum was the main guarantee of the constitutional Switzerland. Of course, maybe that is a quite concrete Swiss history why the referendum functioned there and in other country no. But I think the Vice President idea is more ideological camouflage of state unity, people's unity, whatever, because the Vice President is also a political power like the Constitutional Court. and then why we know why, because Schmidt rejected the pluralist idea of the democracy, and the vice president was assigned a task to defend the unity against the pluralists. So the Constitutional Court is the guarantee of the constitution in the pluralist society, and the vice president is the guarantee of some elitist interest in a non-pluralist democratic thinking.
Okay, thank you so much for also this very clear answers to the questions of our guests, of our audience. I think we can close the session now. I see Valeria smiling, not because of the relief, but because we have just like this time slot, and then once it's over, it's over. I'm very glad that this seminar was so interesting and worked out so well and so nicely. We had a lot of very nice slides, also one with the favorite coffee of Hans Kelsen, which I hope it's still open and we can visit.
No, it's still not open.
Sadly. So anyway, thank you so much, Péter, for your very wonderful lecture, I would say. We look forward to hearing about the next stages of the project, of your project. And I thank the entire crowd of the Center for Advanced Studies for having me in the last 3 months, and especially Valeria for coordinating this seminar. Wish you a good rest of the day and see you soon.
Thank you
very much.
Bye.
Bye. Thanks.
Bye-bye.
Thank you. Bye-bye.
Thank you. Bye.